There are some subtle differences between trademarks versus trade names. Trade names would also fall into what would be a company brand, depending on how it's marketed. For instance, a trade name would be the company itself, Coca-Cola. However, the trademark takes it down a little bit and it actually creates kind of like a funnel effect, and it's going to be associated with a particular good or service. Now, Coca-Cola also has Coca-Cola as a registered trademark, and that's going to be associated with the soft drink and the beverage that they currently sell, but the Coca-Cola company is the trade name. And a lot of people get tripped up, particularly smaller businesses, when they're trying to pick a trademark to build a brand around, because typically you start with one and build out. And a lot of confusion exists because they'll call a Secretary of State and they'll say they want to register a name, and the Secretary of State will simply not have that name in their registered database for a corporation, and therefore they assume, well, I got it with the Florida Secretary of State, that can be my trademark, and I can go out and I can start building my brand off of it. And that isn't necessarily true, because a lot of times, just because the Secretary of State has something that is available, doesn't mean that it's a professional trademark that you can pursue, because oftentimes you'll find that there may be common law uses or other people in other states who are using that particular mark on a national level, and that can create some infringement problems for you. So doing a preliminary clearance to the Secretary of State is a good thing, but it's only one step that you should be taking. And first,
circuit in DC. Another thing you can do is cancellation proceedings. It's a little harder to do that. That means you're trying to cancel a registered mark, which isn't as easy as opposing something that's not yet registered. If you have a mark and you don't catch, if someone hasn't applied for registration, you can sue them, you can look for injunctive relief, you can try and get accounting for profits and actual damages. You can go through, if it's a domain name issue, some of you may be familiar with the UDRP, which is a proceeding to cancel or transfer a domain name that infringes upon your trademark. There's no damages you can get as a result of those kinds of proceedings, but it's much faster than a lawsuit would be, and you can get those infringing domain names taken down much more quickly. There's also potential criminal penalties for trademark infringing. It can range from fines to actual seizures of infringing goods. One thing you can do as well, if you're worried about companies that are importing goods that have a mark that infringes upon yours, you can actually try and get with the Trade Commission in the U.S., you can file something that prevents those marks from actually being imported at ports or wherever they're being imported from. If a customs agent sees something that bears that mark, or is on the report that says, no, this infringes company X's marks, they just won't let it into the country. It'll just sit there.
Even texting these days, which, by the way, if you're in-house counsel, don't text to outside counsel. Texts are notoriously difficult to preserve out in cyberspace. They're difficult to get rid of. They tend to be shorthand. You can't put all the kinds of disclaimers on them that you want. So don't communicate something that you don't want disclosed by text.
Position of distressed businesses. It's important to define your objectives and your goals. Articulate them and document them so you know why you're going after the target and what you want to accomplish, so that if you find out in due diligence it isn't what you want, you don't end up with an asset you don't need and liabilities you don't want. Working through the due diligence helps you identify the appropriate structure to use, so the earlier you start your due diligence, the better. There are, in some cases, although generally you'll want to acquire the assets and won't want to acquire the entity itself, you may discover through due diligence that there's so little likelihood of unknown liabilities, but there's a net operating loss that you want, that it's worth acquiring the interest in the entity to take advantage of the net operating losses or other tax benefits you may have. The other side of the coin is there may be so much risk with respect to unknown liabilities that under no circumstances and at no price would you acquire the interest in the entity.